Thanks, Iman. I'm going to speak now to Professor Alex van den Heever from the Wits School of Governance. And Professor van den Heever, thank you so much for the time. I appreciate it this morning. And I want to go straight into this because it is a holistic conversation. And for anybody at home sitting and wondering why this matters so much, I've been trying to highlight the significance thereof. And I wanted to ask for your help in this regard. If you could just give us a sense of the significance, the importance, why this matters so much to everyday South Africans, and the impact it has actually probably had for at least a decade, if not more. Good morning.
Good morning. So this particular case in the Constitutional Court is not necessarily going to make any determination about whether or not these banks colluded and manipulated the currency. What it's largely dealing with is the procedures that were carried out at the competition tribunal and the threshold for evidence that is required in order to connect parties to an overarching conspiracy. So in essence, it's about evidence and the quality of evidence. And so part of the case that the Competition Commission would be making is that although it's got powers to investigate, to some degree, when you're dealing with foreign companies, you are limited in being able to access all the information. So you require the tribunal process to surface some of that information in the way that the case is pled in the requirements for discovery in response to their pleadings. So what's being objected to at the moment is that there was not sufficient evidence to connect these companies to an overarching conspiracy. And the Competition Appeal Court was allowed to make a determination on what was going on in the tribunal case, and basically then barred these 17 banks from being party to that because it argued that the Competition Commission had not passed an evidentiary threshold, despite having powers to extract information. So part of this is a discussion about whether or not a regulator such as the Competition Commission should be permitted to have a fishing expedition and on the basis of sort of thin evidence, then require somebody to defend themselves in detail in a tribunal process. So the Constitutional Court is there. I think there is a genuine constitutional matter here because it deals with the procedures of investigation in complex cases where the surfacing of information may not be that easy. But the Constitutional Court, I doubt, will be making a determination that allows for freewheeling fishing expeditions by public authorities. And so the question is whether a determination will be made in this particular case as to whether or not there need to be that the Competition Commission needs to be able to work at the tribunal to extract information through discovery without it being a complete fishing expedition. And so how the guardrails are put in such a determination by the Constitutional Court will be important. So I think it is an important matter. The Competition Commission needs to have the ability to deal with complex cases, cross-border cases like this. But the question is, should they just have a blank check to go after anybody with thin evidence of connection? So to prove an overarching conspiracy, you have to show people were connected to this particular case. And if they don't have that evidence, should they be allowed to just drag people into a case where they must then defend themselves in this particular way? So this case is not going to deal with the merits of the case itself, but on the procedural issues. And it will effectively, depending on which way it goes, will send the matter back to the tribunal to then continue. And if it strikes down the Competition Appeal Court determination and then allow all the banks to defend themselves in the tribunal case, and there the matter will be determined.
Yeah, and it's a full circle back to the tribunal that will be determined by this then, which will take it back there. I just find it very fascinating to try and get to the crux of, whether the Competition Commission has free rein or this fishing expedition, as you pointed out, to ultimately deal with situations like this one. And because it's a currency issue that goes so far and so wide. And if the Competition Commission doesn't have jurisdiction to then deal with matters that affect the rand, the big question mark becomes, who does then?
Well, the issues that they've effectively, it can be argued that they do have the powers what they would be arguing is that the exercise of their powers on a cross-border basis are difficult. So if there's collusion with external international entities, firms overseas, that are not even licensed in South Africa, how do you extract evidence from them in that particular case? So the issue is really one of their ability to be able to properly prosecute a case such as this, given its complexity. Now, on the one hand, there is that particular question on a serious matter. The question is whether they have to have sufficient evidence to show connection, even if they don't have conclusive evidence. But what's the threshold? What's the evidentiary threshold that is required? And it's important that that is very clearly understood at the end of this, because to then create a situation where open-ended fishing expeditions are permitted, then essentially you've got a loose cannon. I don't think anybody wants that. So I think that the Constitutional Court potentially can clarify that particular threshold and make it very clear what the powers are of the Competition Commission in this, and whether or not the tribunal process can be used to extract information. What threshold is required to drag somebody into that process and require them to provide additional information on the basis of discovery? That's where you ask the other party to provide certain information that is confidential to them into the inquiry, into the tribunal process itself, and in response to pleadings. So this is very much a procedural matter. In the case of currency manipulation, South Africa needs to be able to deal with this. It needs to be able to make sure that it can manage it. The question is whether it has a case here, and whether or not the processes allow for it to fully investigate this matter without them overreaching. That's really the question. And I think it's quite possible that the Constitutional Court is could consider saying, here is the threshold, here is the clarity, here is the procedure, you're permitted to do this, but here are the guardrails, so that you don't have an authority that basically pushes their weight around. So that's the I think an important issue that will be determined here, and that clarity I think would be very helpful. We've had the arguments of currency manipulation in the 2000s, and that was potentially from a whistleblower who had identified currency manipulation, and it was inconclusive at the end of the day because they couldn't extract the evidence. So there is an important issue here that one wants to have an ability to extract evidence, but not to be unbounded.
I mean, Professor, at that point, when you speak about that case from the 2000s, we actually saw an improvement, or shall we say, an appreciation then of the currency then, which then went from around 15 Rand against the US dollar right through to around 5-6 Rand actually in that process. So perhaps that kind of tells you some of the unwinding of those deals that were happening at that stage. So it's actually very interesting. You make note of that case then, which was the Commission of Inquiry that was inputted by then President Thabo Mbeki. Just as a final question, in terms of governance, do we have a governance issue when it comes to how we trade and our financial institutions? Because you have the King's Code, which is supposed to allude to a lot of things regarding this, but it seems like that may not be playing its part here.
Yeah, so it's a question as to where and how the manipulation occurs. Just remember that the manipulation doesn't necessarily drive the Rand up or down. The manipulation is on the spreads. So essentially what people are potentially agreeing to is very wide spreads, which gives them a higher profit margin. And if they agree to that they're not going to get undercut by a competitor offering narrow spreads, which is actually better for the clients, then they can actually make a higher profit. So that doesn't necessarily drive the currency up or down, but it basically allows for undue profits to be through effectively price fixing and sharing the market. So the issue is on that. So the question is really, have we had manipulation that drove the currency up or drove the currency down? In some cases that might have been the case, but I would say there does need to be some way of intrusively being able to review whether or not spreads are being used, people are colluding on the spreads in the financial institutions in South Africa. And we have a number of regulators, including the Competition Commission, and they do have a role to play in making sure that conduct is completely eliminated.
4 days of hearings is what we're going to be hearing then. Professor Alex van den Heever, thank you so much for your time. Appreciate it this morning from the Wits School of Governance. As the currency manipulation case is set to kick off here in the Constitutional Court, because the Competition Commission has now brought it here, believing that they do have a case, particularly against 13 lenders at this stage, then did have the tribunal and the appeals commission, should I say, then doing away with at least 17 of those lenders. But it's a convoluted case, Iman, but one, as we've been speaking, that matters so much when it comes to our imports, our everyday goods. And it may not necessarily be the competition, the Constitutional Court's decision that is of ultimate importance at the end, but it is certainly a long way to helping to find out what happens in the end and whether the Competition Commission does have that jurisdiction.